The term that is most popular among specialists and laymen alike within the world of Islamic jurisprudence is ijtihad. Even English dictionaries know how to spell it. Very few, however, understand its true meaning. The term usually associated with it is independent reasoning. The idea underlying the word independent is that Muslim jurists exercising some autonomous authority issue rulings on Islamic law as it suits their fancy. In doing so, they issue opinions independent of the texts of the Quran and the Sunnah. Nothing can be farther from the truth. The independence described is affirmed when we look at the method of modern judges trained in Western laws in analyzing issues of Islamic law, as they consider the work of the earlier jurists to be independent of the Quran and the Sunnah. They do not consult the outstanding manuals of Islamic law produced by these jurists. Instead, they go directly to commentaries written on the Quran and the Sunnah by scholars who were usually not jurists. After consulting such commentaries, the judges proceed to exercise their own independent reasoning, usually going against what the jurists have said. Carrying this idea of independent reasoning further, Ijtihad is designated as a source of law, being the work of the jurists that may or may not be consulted. The idea of independent reasoning has been propagated by individuals, we are sorry to say, who know very little of Islamic law. Ijtihad, in simple words, means the interpretation of the legal texts of the Quran and the Sunnah, using literal methods as well as rational methods so as to derive legal rules. It is to be emphasized and noted that there is no ijtihad outside the texts of the Quran and the Sunnah. Any reasoning independent of the texts of the Quran and the Sunnah cannot be accepted as Islamic law. By this we mean that whatever the form of interpretation, literal or rational, a hold will be exercised over it by one or more individual texts. A stage is reached when the hold of individual texts is released and we are faced with an issue which no text appears to control. Even at this stage, any reasoning that has to be undertaken will be linked to the Quran and the Sunnah in such a way that reasoning remains within their fold. It will be helpful to view the entire process of ijtihad, even if it is presented in a summarized manner. Such a summary now follows. It reaches up to the level where the texts no longer have a direct hold on the issue. The first stage of ijtihad is that of literal interpretation. This method begins with actual and figurative meanings as well as context. The four methods of literal construction that yield the rules are applied. These methods begin with the core meaning and stretch the meanings up to the implications of the text, including penumbral meanings. The Hanafi jurists use only these methods for the extension of meanings for the criminal law. These four methods are much more comprehensive than the canons of construction used in English common law. Even the ordinary prepositions and conjunctions are assigned their legal or technical meanings as compared to their ordinary meanings in the Arabic language. It is to be noted that the use of the syllogism is extensive in this process, and in one sense, it is even used as a literal method. On the whole, it is noticed that methods of interpretation at this level are much more comprehensive than those employed in English common law, which may very well be due to the nature and structure of the Arabic language. The literal methods are followed by analogy. In Islamic law, the method called tamsil is used. This is different from syllogism, in which there is movement from the general to the particular, whereas in this form of analogy, the movement is from the particular to the particular on the basis of a common underlying meaning. This gives rise to many methods when we look at the methods of deriving the underlying meaning. Islamic jurisprudence uses the effective attribute, and the analogy is referred to as qiyasul illah. The hold of the text is quite strong, as analogy is undertaken on the basis of texts. In the Western system, the method of analogy used is called qiyaas al-shabah, which relies on multiple attributes seeking a resemblance with the attributes in the case at hand. Analogy is followed by breach of analogy or istehsaan. This method is used in the resolution of apparent conflict between rules. The hold of the text continues in this method too. The analogy arising from a single text is given up by preferring a stronger rule that has arisen from some other text or from a number of texts. There could be other reasons for giving up strict analogy. Related to this method is Maslahah Mursalah, which is a method that relies on a rule in the text that helps solve an issue that is not mentioned in the text. The crucial factor here is the rationale behind the rule in the text, which covers the new case. The text, therefore, is effective in this case too. Finally, we reached a stage of interpretation that breaks the hold of the text and comes up with a case that has not been provided for. Such a case may arise in a newly added area of the law or even in a traditional field that is facing an absolutely new issue. In such cases, unusual combinations of facts are presented which do not admit of a convenient use or extension of existing principles. Dworkin calls such cases hard cases, while the positivists refer to them as the area of discretion. Thus, the case may turn up which cannot be solved directly by the texts through the 4 stages of interpretation or ijtihad mentioned above. Here we say that there is irsal or release on the part of the text. In other words, the new issue has been released into the domain of the text taken as a whole. The text taken as a whole means the ultimate 5 principles, which we call the maqasid Al-Shariah, or the purposes of the law. The new case is called Maslahah Mursalah. That is the new case that has to be decided in the light of the interest protected by the Sharia. It may be mentioned here that for Western law, such new issues may pertain to new fields or to new issues arising from fields like contracts or torts. But for Islamic law, it will mean the bulk of modern issues that we have tried to solve through Western law in Muslim countries. There are detailed rules for the operation of this method, which should be studied to understand the method completely.